Hey, good morning, Mr. Rahman. Ma'am, you're charged with theft. You're facing up to a year in jail and or a $4,000 fine due to the amount. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am.
On February 2nd, 2026, officers were assigned to execute a case for follow-up regarding a disputed purchase. That on 9/22/25, defendant ordered a custom dress valued at $2,000.
Oh, that's right. You told me about this. That's right. Right. Okay,
And it was one in which,
that's right.
she bought multiple dresses.
Correct. I remember now.
Asian wedding. And then the officer called her, they said they had warrant for arrest. She showed me, said she called them lawyers and they could find a warrant, so she thought it was a scam. And so she held the officer back and then they issued a warrant. But, you know, for these types of theft cases, rather than contradiction, you have to prove a fraud at the moment of purchase, which I don't think they have, but.
Well, that's, you guys will, right, just, so you're taking care of everything now. She's not gonna have contact with anymore, right? Okay, so just the only,
How they want us to make restitution.
sure. The only condition is just don't pick up any new cases. Don't have contact with these people. Let Jason work everything out for you, okay? All right, we're gonna have, we'll just have you sign a receipt and then after that, you'll be on your way, okay? All right, thanks, guys. And then, so Jason, it'll be waived, the appearance, so have fun. Good to see you, man. Hi, Mr. Frank, what's up, man? Good to see you.
Good to see you too.
What's up? Who you got?
We have a Kanye with Davis.
Is it under the R or under Davis?
Should be under Redneck Davis.
Dave.
She is.
I see it.
Judge.
Is she not here?
She's not here, Judge.
That's a problem.
And
That is
the reason why I'm here,
a big problem.
Because she's not taking this lightly. But the same reason why she's not here today is the same reason why she has a bond violation. She lives all the way in Toledo, Ohio. She called this case while she came out here on the weekend, got out through, like this, good fight with her friends, and got into false case. She went back to Toledo, Ohio, where she lives. She goes to school. She doesn't have the means to just be able to help up and report for a drug test in Houston.
No. We tell them that, and they're advised that if they're from out of town and they get called to take a drug test, it's their responsibility to go to a Quest diagnostic and then get the result to us. We advise them of this and they know this because we tell that to every single person that resides elsewhere.
Right.
So for them, I don't know what to tell you.
I told her that I would try to get that request from you guys, but what Vikky said, she probably already got that advice.
I don't know. I can't tell
She
you.
didn't seem like she knew anything about that. And she just got the notice to be in court today over the weekend. Originally, her court was supposed to be, I want to say July 8th. And so she got in touch with me immediately to see if I could come here because she does not want the court to think that she is sort of neglecting her responsibility or disrespecting the court.
Did we advise her?
We notified her last Friday.
No, right. Not about just the bond violation, but the fact that she can test at a Quest diagnostic.
No, pretty sure our policy is that they can only test with us.
Okay, so I'll roll this to Wednesday. She must have a drug test to us from a Quest, no other location. She's got to get it to us here by Wednesday. We'll set up for bond forfeiture again. If it's not in hand that we have a test result from Quest, then, I mean, okay, so just reach out to her, let her know at that point. And from here forward, if she gets called, then she needs to test at a Quest and then get the result to us. I can't obviously pay for it because it's at an outside lab, but so we'll give you 2 days to get it done. If she doesn't get it done, then her bond gets revoked and let her know.
Really appreciate that.
Yeah, okay. All right. And then after that, the only other thing I'm gonna say is just please let her know. Don't pick up any new cases. And then they're gonna look in the interim just to make sure that she doesn't pick up any new cases while she's on bond here. Okay? Yeah, okay, thanks.
This one's good.
Yeah, we'll do that next. Yeah, and then waive the signature.
Page 3, Anderson, come on up.
Hey, Mr. Tyser.
Yeah.
Tell me,
I didn't realize you're still.
it's okay. You got something real quick?
No, it's court admonishment.
Got it. Okay. Yeah, that's gonna, yeah. All right, ready? Come on up, Mr. Anderson. All right, good morning, sir. Sir, you're charged with assault of a family member and failure to stop and give information. On the assault, you're facing up to a year in jail and or a $4,000 fine. And on the other case, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On June 6, 2026, officer was dispatched to an apartment complex and advised that there was a reckless driving. Before he believed vehicle was dark color Toyota and gave the partial license plate. Also said that there were people physically fighting inside the car and they struck the fire hydrant. Officer made contact with the witness before who advised she was driving when her daughter observed the first physical altercation and brought it to witness's attention. Witness observed defendant's vehicle between lanes, enter sidewalk, strike the fire hydrant. When car slowed down, witness observed a male defendant striking a female. CW.
Wait, did you say witnesses saw defendant strike a female?
Yes, sir.
Okay.
Witness stated she observed the front passenger door open and CW tried to exit the vehicle. Defendant kept traveling, lost visual, but as witness was traveling to residence, she observed the vehicle with the same damage as defendant's vehicle and the license plate letters were the same. Witness followed defendant and contacted officers. Witness's daughter stated she observed defendant around CW's throat. Defendant denied any physical altercation. Damage to the vehicle was from, and said that the damage on the vehicle was from potholes. Defendant was detained. Defendant then stated he struck potholes, a fire hydrant. Defendant stated CW told him to leave. And drive to residence. Officer made contact with CW who stated no physical altercation had occurred, stated defendant only struck potholes, not a fire hydrant. CW and defendant are in a dating relationship for a couple of months, but they're on and off from 2020, 2021. Officer observed possible injuries on CW's neck and leg. CW stated no strangulation had occurred, no change, no impeding in breath. Officer couldn't tell if the injuries were from the crash or assault. Upon locating the hydrant damage was photographed. Damage to hydrant is 2,500.
Does he have a license to drive? Mr. Anderson, I'm going to find that there's sufficient probable cause to go forward with your case. I'm now entering in what's called a magistrate's order of emergency protection that identifies Ms. McGee as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. You are ordered not to have any contact with this person. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You understand? If you violate these conditions, if you are a danger to my community, I will revoke your bond, put you in jail. There will be no more PR bonds. This is not a revolving door. Do you understand? Okay, we are going to reset your case to give you time to hire a lawyer. So what time of day or night was this? Is there any alcohol, drugs, illegal drugs at play?
21 to 42. There is no indication of drugs or alcohol, Judge.
Okay,
I tried running the driver's license, it wouldn't return anything. There's a driver's license number though.
okay, yeah, if you don't mind running. So KHA, so we'll have it come, and then can you create bond conditions, no contact, no weapons, no driving without a valid license and insurance, please? And then we'll have him sign it here momentarily. Okay, I'm gonna have you sign a reset. We will have you take a seat while we get your bond conditions. Once you sign them, at that point, you'll be free to go. Let me make sure that there's no contact on it. Yep, okay, we're good. All right.
Chavaria?
Edge, Edge, he needs to sign them off too, though, please.
We'll see if you got.
Mr. Thering, do you have an arraignment?
No,
Okay,
you're on.
sorry, let me just float through these real quick. You are Mr. Chavarria. Sir, you're charged with reckless driving and driving on a suspended license. You're facing up to 6 months in jail and or a $2,000 fine on the suspended license case and up to 30 days in jail and or a $200 fine on the reckless driving. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On June 8th, 2026, officer observed defendant's vehicle accelerating to a high revolution per minute. Saw exhaust from his vehicle. Observed defendant traveling at an extremely high rate of speed of other vehicle.
Hold on a second. Hey. Stop. One more time, you're going in back. Sorry.
Speed of other vehicles were far less than defendants. Based on this, officer followed defendant, observed defendant completely disregarded red light. Officer initiated a complete stop, defendant to stop. Officer made contact. Defendant said he was in a rush due to being late to work. Defendant was unable to provide insurance upon DCIC and CIC check of driver's license. It returned not eligible and insurance unconfirmed.
So the statements you made were very conclusory. He's driving at a high rate of speed. I mean, high rate of speed is,
I think some particular speeding locked down, but the officer saw the car going faster than everybody else, paged it, and the stop was initiated when defendant passed the red. It wasn't for speed.
no, he blew through a red light.
And I don't see a driver's license number.
Mr. Chavarri, I'm going to find that there's probable cause to go forward with your case. You are not allowed to drive. You do not have a driver's license. Do not drive. You will be signing an affidavit with me today, promising me that you're not going to drive. If you do, I can have a contempt hearing. Every time you drive, it's an offense in and of itself, 180 days in jail and a $500 fine. Do you understand? I don't care that you have to work. I don't care that a baby has to go to the hospital. If you want to do it, you must do it the right way. Go get a license, get insurance in your name, and then we can talk about you driving. But if you do in violation of this, it's really just not going to go well for you. Do you understand? Not only that, if I find you driving in a reckless manner again, likewise, I will revoke your bond, put you in jail. There will be no more PR bonds for you. We are going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here, swear to us that you're not going to drive. I'm going to have you take a seat while we get bond conditions created for you. Once you sign the conditions, at that point, you'll be free to go. When you come back, please have a lawyer. Okay.
All right, that is the last arraignment, page 34. Redwell?
So on that case, do you mind filing no reckless driving, street takeovers, racing, just no driving? without a license and insurance, please.
Take the sign of
All right. Good morning, Mr. Treadwell. So you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On June 8, 2026, at 12:40 a.m., in Harris County, Texas, officer observed defendant stopped in his car past the red line on a public highway. Upon the light turning green, the car accelerated at a high rate of speed and reached the speed of 70 miles per hour, where the limit was 35. Upon performing a traffic stop, officer observed defendant was the sole occupant and located the black Glock 2240 caliber handgun in the storage pocket at the rear of the front passenger side driver's seat, which was within arm's reach of the defendant. The defendant was not required age to have a handgun. According to his driver's license, officers did
Why'd they start searching? I don't think I heard a reason, right? It's not in plain view. It's in some kind of, is he driving while black or something?
Oh, they observed they observed the grip and the rear portion of the gun through the back window.
Yeah. I'm going to find no probable cause. Be careful, man. You know, really. It's a lot of guns and hands that have no business having it. And God forbid, right? You know, watch the news, my friend. Please.
Council for reset.
Hi. Are you ready, Penny? Good morning.
An off-docket case,
From the other day?
yeah,
Okay.
and do you know who his name?
No.
I talked to pre-trial, we were at Quest Labs, and he works, he's here to also explain his job. His employer is in Calgary, Alberta, Canada. They don't have Quest Labs. I contacted National Screen here, and if you allow him to go, he has to go quarterly to Canada. They can do a hair follicle test that makes it on return, it goes 3 months back, and it is Quest. And he can still do
Where,
a drug test here.
give me, what is your cause number? Please.
The cause number.
Yeah.
He has to 262246201010. He's a
On.
licensed CPA, vice president of the company.
How long is he going and
He has to
when?
go a week.
He's going for,
August 3rd is he can waive all appearances except he has to go August 3rd.
okay, so he's going in August.
Yes,
Okay, and then how long is he going for?
he goes for a week.
Okay, I'm okay with that. So, right, just tell him not to use. That's fine. We'll do hair follicle when he gets back.
Okay.
It's on him though,
It's on him outside.
right? And then we'll see. Just tell him not to use and we'll,
Okay.
I'm okay with that though. Yeah,
Thank you.
Last name,
just let Veronica know, please.
Morning, Aaron.
Please, yes, sir.
Morning.
Hey, good morning.
Back on Mr. Marcus Perez. Last week, we went ahead and updated the court that he had a TRAS in July 1st. The court reset TRAS said today for walk with TRAS.
Yeah, sure.
Show up and do it.
Okay,
So we just want to see how much
Yeah.
time for order to reset.
just a couple weeks for you to finish it up. Hmm?
Thank you.
2.5 weeks should be sufficient, I think. Yeah, okay, for sure. Hi.
Thank you, Councilman.
Yeah.
she's PT program.
Wonderful. Great, so we'll give you time. Okay, 2 weeks. Yeah.
Hey, Jess, good morning. How are you?
Hey,
Hey, I got eyes on Rodgers in custody.
okay,
Last week, you revoked and raised it because he had some unapproved enters and leaves while on his curfew. Like 2-3 minutes at a time, probably 3 or 4 times on a particular night. I just got worked out a deal with the DA where he's gonna do 30-day PTI, effective decision making. Would you,
I'm not going to reinstate his bond.
would you reinstate the bond to allow him to get out, take the course?
No, it's a third bond violation, you know, it just, I'll certainly give you a bond reduction, but it's not a revolving door.
No, I understand. I think he's been in custody over the whole weekend. I think that's a punishment for him, you know, for violating his bond conditions. But like I said, I want to try to move him through the system, get him to take this class and maybe his life can improve.
What do you think?
I wouldn't have any objection to that as long as I understand that there's a way to also put the flag on.
Yeah, I inquired, it appeared that that's the attorney with the laptop hanging out, clicking the buttons for him while he reads it through the holdover.
Trading?
So defendants that are in custody, if they get a effective decision-making course offer, the attorney has to literally sit there in the holdover and click it through with the client.
Sucks. But actions have consequences, don't they?
All right, I understand.
I understand he's given a great deal considering his criminal history, right? But nevertheless, it's just bond violation after bond violation after bond violation here.
Right. No, I understand your point. I'm just trying to figure out how to do this mechanically, you know, to get in and take that class.
I don't know. Give me time. Let me get everything out and then I'm going to bring him out and I'll talk to him.
Sure.
And
Okay.
we'll
Thanks.
see. Okay. This device has a dead battery now. This is Avila. It has a dead battery.
I think that would be right with the officers and the check. I have not seen any updates this morning.
You were ordered to get a GPS monitor and you have not kept up with that monitor, Mr. Avila. And I have seen now that the battery is dead and you are not being supervised in violation of your bond conditions. You're on deferred for a very serious case upstairs, and yet in a week or yeah. Sorry, you leave me no choice. It goes with you. I'll appoint your lawyer now, Mr. Avila, but dead battery, dead bond.
I'll pick up one side.
Sorry, bud.
We've taken text of since last week.
Yeah, it's
Council President.
5,001. All right, counsel, coming up. Yes, ma'am. Yes, sir.
Sorry about my third one. 262.
Is it on docket today or no?
It's not on docket.
262
4265.
4625.
4265.
4265.
Right.
Got it.
Approaching on this one, we found out about a warrant.
Okay, you mind, is he here?
He's upstairs. We found out about a felony warrant. Took him to the 48. And he's in custody there. They're dismissing that case.
It looks like it's been dismissed now.
So they said that because there's a warrant, I could not bring it.
I can't, I don't know. I mean,
They already have the custody.
He's sitting in the holdover. I can go back to the next judgment to get if he can come down with me, but they said I had.
right, I can't. I don't have enough to go get him because he's constantly in and out back there and she's here with me. If you can ask them to escort him down here, I'm happy to do it. But yeah,
Okay.
for sure. Who's this?
Bargna, B-A-R,
Bargna. Are you here for someone else?
Rashad.
Got it. Okay.
He's in trial.
All right, you are Mr. Bargna? Sir, you're charged with driving while intoxicated. It is elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On June 7, 2026, officer was on patrol when he observed defendant's vehicle positioned hazardly facing eastbound in a westbound lane with a portion of it resting off the roadway in the grass. Officer observed significant damage to defendant's vehicle. Officer made contact with defendant. He was a sole occupant, denied driving initially, then admitted to hitting the curb and consuming 3 beers at a bar called Below Deck. Defendant had bloodshot, glassy red eyes, mild odor of alcohol on his person and breath, several mental disorientation. Defendant stated he was coming from the UK. SFSPs were 6 out of 6 HTS, 6 out of 8 walking 10, 3 out of 4 1 next 10. He consented to a breath test, which came back 0.35 and 0.27.
Any prior DWIs?
No previous use.
Alcohol in the car?
No test.
Okay, Mr. Bargna, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be tested. If I find that you're using, I will put you in jail. No more PR bonds for you. I don't know if you have a problem with drugs or alcohol. If you do, now is the time for you to address it, because if you don't and it becomes a problem, I will do it for you and you're not going to like the way that I do it. Do you understand? Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them.
Thank you.
Does he have a license to drive? You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand? That is also a condition of your bond. For now, we'll have you sign a reset. You'll get with Veronica for your bond conditions. Then after that, you're free to go.
Thanks, Judge.
Does he have a license, Carson?
Yeah, it's UK.
UK.
Is he living in the UK? Is he living here?
I'm covering from shop, Judge. Are you living there or? 18 months.
I'm going to put an interlock then. He doesn't have a text. Let's put an interlock just in case, especially with the high blow. I'm ordering you now not to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock,
No telling you where to do that.
you will go to jail. Do you understand? Okay, thanks.
Thank you, Judge.
All right, take care. Okay, Mr. Fox,
I'm here on Mr. Vance.
say it again?
Mr. Vance. I'm on the considering for the bond.
Ready?
I am here. Good morning.
Hey, good morning.
I was here on this, Edward.
Can I give you a cause number?
Yes, yes.
It is,
357.
yep.
8510.
Miss Edwards, come up. So obviously can't trust her. But-
And absolutely frustrating.
Really? Do you see how,
Well, it was all in one instance. Well, those two, I know it's multiple blows, but it's while she was driving, you have to continue the blow.
and she's blowing positive.
She would.
Wasn't one.
So, ma'am, I'm going to alter and amend your conditions to put a scram on your ankle so I know that you're not consuming alcohol. You're on probation for a DWI. And I mean, it's either this or jail, really. You're ordered not to use and you're have a ton of positive blows. I'm not going to take your word for it. I can't. This is a probation. Not only that, while you were on bond in this, for us, the multiple times, you had multiple violations while you were on bond in and of itself. So it is a repeated occurrence. I can't trust you now. So the only other than jail, my only other recourse is to put a scram on your ankle so I know that you're not going to consume alcohol. Or a portable device, I guess, either or, but
Your Honor, if I may, she started probation in February of this year, and I believe she had no positive blows, no violations, no nothing.
for 2 months. And then she blows positive.
Well, Your Honor, she was actually going through a period, found out that the boss had cancer. The boss consequently died, and that was kind of the crux of the drinking. Those multiple positive blows are from the interlock. But it's, if you look at it, they're all on the same 2 days, like I think it's 3 or 4 from her blowing the start and blowing to continue to drive. In essence, there's only 2 positive blows. I mean, I know it's 4, but there's only 2 instances. Your Honor, also, she's just started IOP. She has not had any other issues with alcohol since then. Your Honor, we ask for a strong admonishment at this point and allow her the opportunity to show that she can abstain from alcohol use in lieu of discretion.
I think really the prudent thing to do would, at the very minimum, would be to give her a portable device for the time being to ensure that she doesn't consume alcohol. I mean, 2 months into the probation, she's already consuming, right? The following month, she consumes again. While she's on bond for the DWI, she has 2 different bond violations. It's a repeated thing, and it continues to happen. Either you have a problem with alcohol. If you go out there and you kill someone, do you think it matters that your boss died? Do you think it matters that the person had cancer? No. Justifications mean squat when you're on probation. There is no justification. The only repeated thing that we have is you picking up criminal cases and having bond violations. I'm doing everything in my power not to put you in custody now, but we're well within our right to do it. But if you think that you get to have continued violations and you're just going to walk out of here with a pat on the back, life doesn't work like that. Actions have consequences. And Ms. Edwards, let me tell you that we have reached our limit now. If this doesn't work, my only other recourse is either jail or inpatient treatment, because I really have nothing left at my disposal. Do you understand? We all have issues in our life. We all have stressful situations that we're dealing with. What defines you as a person is how you deal with that. You can deal with it in a constructive way. You can go exercise. You can take a painting class. You can get a dog. There are many ways other than alcohol or illegal drugs. But it's very easy to hide oneself in a bottle. That's not the way. Do you understand? If we have this conversation again, it's not going to be a happy one. So please, if you have any further issues, find another release. Do you understand? Okay. So let's amend it to put, she has 3 days to get the device, and we'll go from there.
And, Your Honor, is there, she does already have the interlock. Is there a specific period of time that you want the portable?
I don't know, but at this point, she's been on probation for
Oh, well,
4 months, and 2 out of those 4 months, she's tested positive. Really? We haven't even made it, not even,
Council
Okay.
Forfeiture,
thanks, Your Honor.
good luck. Did you want to talk about something else? Carson?
Yes, sir. Gordon Emlock, but he has a rental car for 18 months because he works for HGX, which is a soccer club in Houston. He's here from Manchester. So I don't know if we could do a portable with a below schedule.
Well, then,
Just because services can't put an interlock in place.
that's a problem.
Work too, John.
Say it again?
A portable. And he has no criminal history. And you can at least give him 30 days, so he's flowing in it like he should and said no hots, then he's showing the court he has a pattern of compliance. And I think he understands the levity of the situation.
2.6 is really, that's nearly 4 times the legal limit.
Understood.
All right, we can put a scram, but I want verification that he has insurance before he drives. So no driving until we're able to verify that he has a valid license and insurance.
Thank you, Judge.
Yeah, and we'll put a scram so we know that he can't just skip.
Yes, sir.
Okay, all right. Good morning, Mr. Ballard. Do you have a lawyer today? Tell me what you're doing about that. Tell me what you do. You need a lawyer. You're facing a year in jail. Have you made any attempts to hire a lawyer? That was not my question. Did you make any attempt to hire a lawyer? What did you do? You made a phone call? How many phone calls did you make? How, what do you do for a living, Mr. Ballard? You drive trucks. How much money do you make a month driving trucks? You don't play. You know exactly how much money you make. How much money do you make a month driving trucks? 4,000. And who do you live with? So how do you know you can't afford a lawyer if you've not talked to any lawyers?
I have talked to lawyers. So the negative goes for it.
There are thousands of lawyers in Harris County. 99% of them will put you on a payment plan. If you ask for a couple of $100s a month, they'll represent you. But it's a matter of you, like a car, like shoes, finding one that fits, right? You have to go out there, you have to make the phone calls, you have to make the effort. We don't just give out lawyers like it's candy on Halloween. You have to really be at the federal poverty level, which is making $15,800 a year to qualify for a court-appointed lawyer. I do not have an unlimited number. If I have someone who has 5 children, Walmart is trying to get food and clothes for the kids, if I give you one, I may not have one for that person. Do you understand? Right. So we're going to give you a little bit more time. I'd like you to really make a concerted effort. You may need to talk to 20. You may need to talk to a little bit more. But this is a serious case. You're facing a year in jail. You understand? Please.
this way.
You have to understand, you're headed off to TDC. What that means is that if you pick up a serious felony from now on, you may be looking at a 15 to life from now on. Do you understand? So got to be careful out there. You're charged with 3 cases with us. You're charged with assault of a family member, assault, bodily injury, and a criminal mischief. So the agreement is they're going to dismiss the 2 assaults in exchange for the plea on the mischief.
Yes, sir, that's correct.
You're facing a year in jail. The agreement that you've worked out is 180 days in jail with credit for the 148 days that you've done. This charge will now go on your record. From now on, it's a minimum of 90 days in jail should you pick up more cases. Do you understand? In misdemeanor court, that is. You are giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers if you are not a citizen. There are possible immigration consequences. You can be deported excluded from the country, deny naturalization, you give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Is this what you want to do? How do you plead to the offense of criminal mischievement? I'm going to find you guilty. I'll follow the agreement. Good luck to you. Thanks.
Thank you, Your Honor.
Thanks. Great. All right. Good morning, Mr. Selvage. So you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 15 days in jail with credit for the 5 days that you've done. You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers if you are not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this or undo this. Is this what you want to do? It looks like you have 3 open cases and they're going to dismiss the 2 in exchange for the plea on this trespass. Is that right? How do you plead to the trespass, sir? I'm going to find you guilty. I will follow the agreement, sentence you to it, and good luck to you. Your 2 other cases will be dismissed. Thanks, you too, buddy. Mr. Thering. Hey, please.
This does look like a case that's a little bit of a look out, whether it has some benefit there or not, we'll see it on. I'm going to explain what happened her last, her second bond violation, if I may. I know what they are. Case of pre-trial says the alcohol can't be confirmed. She added this that she had handled things. On a personal note, I know the family through my wife's church. I had them in office on Friday. There are some institute facilities, family's going to look at like we're in. The offer has been made, and it's not that offer, but I would like to give my hand back now a little more. There's not a real witness and what have you to do my due diligence job. I'm going to ask the court not to take any action on the allegation. There's a reason why. Maybe a couple weeks to see if there's facilities which will help my position negotiating with the prosecutor possibly. There's other things that she's gone to since Friday. She's attended 2A meetings. She's actually got a chip. She has a book with sponsors' names in it. She's done everything I've instructed her to do. No, that doesn't make up for the possible alleged.
Come up. Come up. Mr. Thering, you know,
getting her license up to date and specific. She hasn't, it's not driving. It's written yes or no, sir.
What's the last name again, please?
It's a hyphenated Alvaro.
That's, I appreciate your tenacity, but this is a 4th bond violation report, Mr. Thering.
The other 2 were in BACs, right?
It's a 4th bond violation. For some reason, we are not getting your attention.
No.
Stop. It doesn't matter. It is a 4th bond violation. We are not getting your attention. As much as I love you and appreciate you, Mr. Thering, this is a 4th bond violation. And it's not fair to everybody else because anybody else that has 4 bond violations, that's it. It just doesn't matter. And I've told you since the first violation that it is no tolerance going forward. So you really have tied my hands because if I let you go now, I'm telling you this behavior is okay when it is certainly not. When my child does something wrong, come on, buddy, I told you not to do it. He does it again. Come on, I told you I'm going to spank you next time. And then he does it again, and I don't spank him. Come on, you've done it twice, and then he does it a 3rd time. And then he does it a 4th time. What is the value of that? Sorry, Dad. What is the value of that? Sorry. We are here on a 4th bond violation. You understand? Right. I can't continue to do it. Somehow I have to get your attention. And now the only other thing I have left is just to set your bond high. Because I have really, truly bent over backwards not to put you in jail. Sorry.
Yeah,
She's going in.
Work the case out, since I told you that, also from the state, and give you 2 months for probation.
Whatever you want to do.
Okay.
The problem is that if you get on probation, because I don't know what's going to happen, but if you get on probation and you think that it's going to continue like this on probation, we have treatment facilities in the jail that are at a minimum 9 months to a year and a half, depending on how well you respond to treatment. Do you understand?
Yes, you're in.
Okay, please. So it's up to you, whatever you want, but really, it's not fair to everybody.
The way you phrase it, absolutely. Yeah. I mean, obviously, there would be explanations, but definitely.
After a fourth, it's just
I think
whatever you want to do. I'm really, you have my blessing with whatever you need, really. I don't think time served, I don't, but
But we looked at some inpatient facilities. I think we're going to do.
that's, I think, more before she graduates to something where you really, right? Yeah.
Thank you, Judge.
Yes, sir. Thanks.
Judge Bond, will you raise or just?
No, I'm going to raise it. Yeah. Is this Jackson?
Yes, ma'am, what's wrong?
Yeah. I don't know yet. Sorry. Good morning, Miss Jackson.
Good morning, how are you?
Pretty good. Thank you. It's Monday, right? Ma'am, you're charged with that. At least we have Friday, right? You're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you have worked out is 9 days in jail with credit for the 4 days that you've done. You need to understand something very important, that this is an enhanceable offense, meaning that if you continue to pick up theft cases, at some point you'll get hit with a felony and you are looking at years instead of days. I don't know how many prior thefts you have, but if you have at least one, this now makes 2, and on a third, you're looking at a felony offense. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, this will go on your record. You can never change this, so undo this. Do you understand?
Yes.
Is this what you want to do?
Yes, sir.
You have a prior theft from actually July of this year. This now makes 2. What happens on the next? Right. Be careful. You understand? All right. How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'll follow the agreement, send it to it. Good luck to you, man. Thank you, sir. Ready?
Hey, Judge.
Hey, what's up?
Good morning, Judge. I'm here on this Dozier. DOZ.
Okay.
Judge, a couple weeks ago, we came in here on an arraignment setting for Mr. Dozier. This is the one that has the travel already planned, booked, paid for to Ireland, starting 6/19 to 6/28. The court had imposed random drug and alcohol testing. She's been calling in, texting, whatever she's supposed to do like normal. The court had requested us to come in with a creative way to make sure she's.
What are you thinking, stinking?
Judge, I have found an accredited lab that operates in Ireland. I'd be asking her to submit to the test before she goes to Ireland, whenever she comes back, as well as submitting to a random.
Let me ask you this. How far back do hair follicle tests go back? And can they test alcohol?
I don't.
Or can we send her with a device like a portable?
So the device, Judge, like it's gonna work because it depends on differences, Wi-Fi, everything like that, according to the previous.
Okay.
But the example that should be submitted to overseas, customer with all the drugs of abuse plus alcohol.
What lab are you looking at?
It's called a better to know, Judge.
Better to pay for.
Well,
That's my,
given the prices, they're very proud of it.
really?
I don't,
Tell me, how much?
what is 195 euros?
About 250, maybe 225.
Yeah, very, very proud.
How long is she going?
9 days.
Okay. So we'll submit to that. So if she gets called to within that time, I mean, are you going to be able to reach out to her?
So Judge, there were two locations on her,
The idea though is that it's random.
right?
I'm okay with you doing that, but I would like it random. I don't want her to be able to prepare. So, okay, I know I got to take a test on Wednesday. All right, I'm just not going to stop. I'm not going to drink for a day. You know, you know what? You would think so. You know, you would really, really think. But
She's also not that.
if I had a nickel, as they say. So,
Judge, the only part about the truly randoms is there is one location that does not have a testing site.
well, everything in Ireland is relatively close, isn't it?
I've never been.
I think it's relatively close. So let's do it random. Okay. And what I would say is contact via email. Because I don't know if you're going to be able to get on the phone. So just they'll email her
Okay.
if they do. I don't know. She may not get one. I don't know. But if she does, then just go to that, what you're saying.
And probably with pretrial about the email address, they don't results into.
Okay.
If you know that.
Okay. All right.
All right.
Yeah. Thanks. Yeah.
If she just happens to get something during.
If she gets selected during that time, then that's where she has to go. And we need to make sure that we get something from them. Yeah. Okay.
And I guess, Judge, I'll get with pretrial about the kind of the timing of everything with the time change. I just don't know what kind of window that they want. And I don't want to.
Usually it's about 4 hours.
Sorry, Judge.
4 hours.
Wow.
From the time that you get selected, you have to go within 4 hours.
Okay.
So they give you about that time to go.
Okay. I just didn't know if they were going to be telling her in US time or in Ireland time.
US time.
Okay.
Yeah.
Get it done. Okay. Thanks, Judge.
Thanks. Hey, good morning. Wait. Hold on. Rosales? Gonzalez with a G. Okay, Frank, what's up?
So, yeah, I got the mitigation package, it is out of town, so.
Karina's here. She'll tell you whether they accept it or reject it.
Yeah, fortunately, she rejected it, but the fire, she did not. I mean, she rejected just the no mitigation package at all. But because it's five, I'm turning in the mitigation package, I'm supposed to make sure it'll be accepted. And, I got everything, we're turning it in today.
But if you give it to her, she'll look at it now.
Okay.
And she'll give you a decision right now. She's a division.
Okay.
Yeah, she'll tell you right now.
Okay. Yeah.
Ariel.
Good morning, Judge.
Hi, good morning.
I have two clients on docket today.
Okay.
The first one is last name Mitchell.
Jail or bond?
In jail. This is a violation of protective order.
Okay. What's the word, Thunderbird?
Can I reset him to July 14th?
Yes. I mean, do we have a resolution kind of close? Because you're got 150 days. Oh, he's got.
I just signed on today. I really want to reach out to.
Oh, you just signed on today. Oh, well, then obviously, I thought you'd been on it because it's 150 days old.
Yes, it's pretty old. I'm not sure why he was never assigned it. Well, it was just this violation. I don't know why this VPO.
You just got rearrested.
Oh, he just got rearrested. Got it.
Okay.
Okay. Yeah, we'll give you 30 days.
Okay.
After felony, 714.
You want the
714.
Do you know if he's going to bond out?
He's not. And on one of his felonies, he's at no bond.
Okay.
So he's not going to bond out.
All right. Okay. Who's number two?
And then number two is Mayorga, if we can read probable cause.
This is a false report, right?
Correct.
Okay, are you ready?
Maxwell.
Mayorga, yeah.
On 2/16/2026, officer responded to life in danger call for service. Reporting party contacted emergency services stating he had been shot in the leg and was bleeding, but refused to provide details of location or circumstances of injury. Reporting party further advised it was a drive-by shooting and that he was hearing voices in his head. Subsequent attempts to establish contact was unsuccessful. Upon arrival, officers located the defendant, who had called 911 to get a ride home and was not shot.
Judge, if I may. For a false alarm or a false report, the defendant has to knowingly initiate the call and has to know that the report was false or baseless. My client was suffering from a mental health crisis. He has schizophrenia and he was hearing voices in his head. He did not possess the requisite of knowing that this report was false because he believed that he was actually going.
How do we really know that though, Ms. Strong? I understand what you're saying, but I mean, imagine if that were the case and anybody could just say that, right?
I understand. It's just because the DIMS explicitly state, and after speaking with my client, that he was hearing voices in his head. And these were the reasons why he had called the police.
What do you think?
But that's what he told them, Judge, because of being that was true. At the same time, when they got there, he needed a ride. So, also it's a fact issue, the trial.
Yeah, I mean, I can't just really take his word for it. I mean, imagine, because then, imagine how the floodgates would open if that were the case, because then anybody could really say that. And
I understand. And according to his orange sheet, he has been diagnosed with schizoaffective disorder just as recently as May 27th of this year. So in conjunction with the diagnosis.
Do maybe the mental health.
My argument is just based off of the intent, based off of his orange sheet, which he's already diagnosed with schizoaffective disorder.
Yeah, I understand. I appreciate, but I can't just take his word for it, and
Understood.
Yeah, I mean, I think there's probable cause.
Okay.
But beyond a reasonable doubt, maybe something completely different,
Understood.
So tell me about him. Does he have somewhere to go? Does he have someone that'll take him?
Currently, he does not have anywhere to go. I emailed the state, and if they were willing to dismiss, I was going to file jail releasing instructions for him to go to the Harris Center so that he can receive further treatment.
Do you want to set it for a couple days to see if they're good with that?
Yes, I will reset to Thursday.
Okay. Yeah. All right.
Okay. Wait, let me make sure that's not the day of the game.
Okay. We'll put them on for Thursday for you then.
Thank you, Judge.
Vic, did you hear that?
No.
Sorry. At top of 48, if you could put on for Thursday, please.
Okay.
Thank you, Judge. May I be dismissed?
Yes. Thanks, Ariel. Appreciate it. You're back.
I am, Judge. It's no good deed. No good deed. Mr. Brogna, he's here, like I told you, on a work visa, 18 months, working with HTX Soccer Club. He has to rent a car. He can't buy a car. The problem is it's a soccer-specific job. He will get terminated if they see this. And that's why I was hoping we could at least give him a test run on the portable. Zero tolerance, making sure he's blowing into it 3, 4, 5 times a day. He doesn't care. He'll blow into it as many times as you want. He just has to keep his job and doesn't want that scarlet letter with the soccer club because he says he'll lose his job.
And are we supposed to feel bad?
Judge,
You know?
I'm just here
Really?
advocating for my client. I don't know.
Mr. Bargna, come up.
He's over here. And I can let him articulate it.
I don't want you to say anything. You have the right to remain silent, exercise that right. But we are not in the business of making decisions because we feel sorry for people. We make decisions based on evidence, based on criminal history, based on what the facts show us. And you have a 0.26. That's nearly 4 times the legal limit. And I don't know whether you have a valid driver's license. I have no clue, right? I don't know if you have insurance. All I know is that is a damn high test. And actions have consequences. And what we need to do here is ensure that our public is safe. I don't know if you watch the news, but every single day, someone dies in our county from an alcohol-related issue. It's just not fair. And what do you want?
I was seeing you could allow him to try the portable for the next 30 days. He has 0 violations. There's no issue.
Well, no. I'm not going to commit to the 30 days or not. I mean, my point is, and the problem that I have is that with a portable device, it's very easy for people to just, all right, I'm not going to blow in it today. I'll blow it maybe later. I'm just not going to. I know you say no, but do you know how many I see a day? Do you know how many people tell me my suit looks good? Do you know how many people tell me that I've got a great head of hair? Huh? Right. We make decisions based on evidence, and I don't know.
What about with weekly drug screens? Where he'll come check in and do 10-panel drug screen also every week. I'm just trying to keep the man stateside, to help him keep his job, and obviously with the understanding the court wants to make sure the public is safe. Nothing in his criminal history suggests it. Yes, it's high. I think that sometimes, to your point, get a wake-up call, slap in the face, and they go and sin no more. And so I feel like that we have one of those test cases here. He's willing to do whatever the court would like him to do. He just would like to keep his job and show the court that he's not a danger to himself or others. And so I'd like to at least give him an opportunity.
The problem I have is would be very easy for him to just get loaded and get into a car and drive. And I would have nothing at my disposal to prevent that from happening if he goes out and kills someone. That's the problem I have.
I do understand that, Judge.
How do we prevent that from happening? Because that's the ultimate, that's why we put interlocks on cars. And you're telling me that you can't do it on so the only other way I know to ensure that he's not drinking is with a scram. So we can't do a guardian interlock. We can't do a scram. I mean, it's like, should we just give in and give him a pat on the back too and start rubbing his shoulders too? I mean, really.
Affidavit of non-driving. He just can't drive. He's got a Uber and Waymo everywhere. I mean, that's an added cost that he's willing to absorb.
All right.
Affidavit of non-driving.
So here's what we'll do. You're going to sign an affidavit, and let me be frank with you. If I find
Texas, so he needs to understand it's not like Manchester. So
if I find that you drive, I can have a contempt hearing. Every time you drive, it's an offense that I can hold you in contempt and throw your ass in jail for up to 180 days. Do not drive. You will also do AA 3 times a week, every Monday, Wednesday, and Friday, and you must keep a log, and you need to provide for pretrial services every Monday so that we know you're doing AA, no alcohol. And let me tell you, if I find that you skip one time on the portable device, you will go to jail, and I'm going to make your bond high. Do you understand?
Clear, Judge, can you explain to him about the onus of charging this device? If you're not charged, or if it goes off, or he can't see that you're blowing it, he's going to assume that's a positive. You can't come in and say, I've got the charger, or it didn't get on the charger. He's going to assume that you're positive and didn't blow it intentionally. You have to be on top of charging the claim. It is not the most reliable device sometimes when it comes to that perspective. You need to stay in contact with your vendor, make sure you have a good device, make sure you're charging.
The other thing is this, Mr. Bargna, you know, I may look dumb, but we weren't born yesterday. If you try to come in here and say it's mouthwash, it was a tequila lollipop, it was hair dye, it was your best friend's wedding, it was a cake that you had no idea it was king's cake or whatnot, it is just as bad. So don't use anything that has alcohol in it, toothpaste, anything. Do you understand? I make copious notes so that I know exactly what transpired here today. I know that I've advised you, so if you try to come in here and tell me it's mouthwash, do you understand? Okay.
And then sign it.
Yeah, I mean,
Oh, you got it? Okay.
yeah, but
Thank you.
I've completely acquiesced to you, but it's no tolerance.
Yes, sir.
Should he have a violation, do you understand?
He's gonna revoke your bond.
Okay.
He's going to jail. It's not gonna be pretty. Thank you.
Okay, thanks. Just don't leave yet because we have a bunch of stuff for you to sign.
He said that's fine, dude.
Are you sure you want to do this?
Yes, Your Honor.
Okay. Ms. Alvio, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement. They're offering you 180 days in jail. However, that will be probated for 18 months. You need to understand that this charge will now go on your record. It will be there for the rest of your life, even after you die. It's still there. Every time you get pulled over, officers will see this. If they smell alcohol, if they smell dope, what's going to happen? I don't know, but it's a very big possibility. You need to understand that from now on, it's a minimum of 30 days. Is it a 15? No, it's a minimum of 30 days in jail. Should you ever pick up another DWI, there are no more proverbial slaps on the wrist. Do you understand?
Yes, Your Honor.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you are stuck with this until it gets completed or it gets revoked. If you do something to violate this agreement, we issue a warrant. We will have a hearing. If you violate this agreement, you're looking at 180 days. You understand?
Yes.
How do you plead to this offense? Guilty or not guilty? As part of this agreement, to complete this successfully, you must do a TRAS. This is an evaluation to see if you need other conditions. If they assess other conditions, you must fulfill them. They may say you may need intensive outpatient support about whatever it is, you must fulfill them. No drugs, no alcohol, a DWI education class, 2 victim impact panels, substance abuse treatment, as indicated by the TRAS, 20 hours of community service, a $100 one-time donation to a $50 one-time donation to Mothers Against Drunk Driving. And you must maintain a guardian ad litem. One more thing, there is no breath test refusal. If you get pulled over while you're on this probation and an officer asks you to submit a breath test, you must do it while you're on this probation. Does she have a license? Do you know?
She does, Judge, but I believe she needs to pay the restricted license fee for it to be valid.
So it's ineligible at this
It's
point.
ineligible.
You are not allowed to drive. You will be signing an affidavit promising us you're not going to drive. Understand that there's no justification in this life that you can give now until, number 1, you get a license. Number 2, you get insurance. And number 3, you have an interlock. If you drive before all those and you get approval from us, it doesn't matter if there's a burning building, you have to say 50 kittens. It doesn't matter. We take it extremely serious. You understand? All right. Did she say guilty? Okay, I'm going to find you guilty. I'll follow this agreement, send it to you. Good luck to you, man.
Thank you so much.
Okay, all right, thanks. Did they file an attorney record so that we attached Mr. Thering to it? He did a motion to sub, right? Yeah, because I want to make sure that they were attached and that Ally was with
Oh, yeah.
Mark Thering. Yeah, okay, great. All right. Hey. Mark Metz,
Yes.
can we get a translator? Oh, great. Hello. Oh, this is with an H, if I remember, right? Mr. Huete, you are charged with driving while intoxicated. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On June 7th, 2026, at 2:30 PM, officer was dispatched to a car crash. Officer noticed an odor of alcohol, intravenous breath, slurred speech, and fussy eyes. Officer noticed empty Corona bottles and more in a box in defendant's car, a total of 15. CW stated he was stopped at a red light when his vehicle was struck from behind. CW stated a passenger in defendant's car started to run away after defendant hit him. Defendant admitted to drinking 7 beers. Still sobriety test was 4 out of 6 HGN, 5 out of 8 walking turn, 3 out of 4 one leg stand. DIC was red. Defendant consented to a red test, which came back 0.254 and 0.243.
I would venture a guess that it's elementary that you're not to have alcohol in the car while you're driving. And if it's proven at trial, it's a minimum of 6 days in jail. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will now also, you're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will put you in jail. I don't know what your immigration status is, but if you are not in this country with proper permission and you go to jail and immigration finds you, they may very well put a detainer on you and you will sit in custody for a very long time. Do you understand?
Yes, sir.
Does he have a license to drive? It's eligible?
Yes, I do.
All right. So you are not to drive any vehicle that doesn't have an interlock. I send notice to DPS in Austin so that every police officer in this state knows if they pull you over and that car doesn't have an interlock, they will take you to jail. Do you understand? Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Metz. If he tells me he cannot get a hold of you, or if you pick up a new case, then likewise, into jail you go. I will revoke your bond. For now, we'll have you sign all the documents, and then after that, you'll be free to go. Thank you, Martha.
Does he have a Spanish teacher?
Okay. No, he's good. He's got a license.
12 and 13. Chavez?
Mr. Chavez, do you have a lawyer today? What have you done to look for a lawyer?
I'm still looking, but they are all very expensive.
How old are you, sir?
21.
How do you support yourself?
Well, working, but the thing is a little complicated right now because I have not been able to drive.
How do you, what are you doing for a living?
I work in construction.
And what kind of money do you make a month?
Around 600 per week.
And who do you live with?
With my wife.
Do you have any children?
One on the way.
All right, I can have you fill out an application. We'll see whether you qualify. I need to know everything about you, and I need to know whether your wife works as well. And you need to put total household income. And then I'll take a look to see whether you qualify. You have a plea on, is Webster with
Yes, Your
you?
Honor, I do, Judge.
Is it a true first on Webster?
Yes, she does. She doesn't have a name and she's a US.
No? Okay, great. Do you mind bringing him up?
Of course.
Please.
Judge, I ask you, I moved him up because he's done a great job. Can we leave him today and have him turn himself in the case Friday? Friday.
Sure, of course. Yeah. Mr. Webster, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 15 days in jail with credit for the 1 day that you've done. You need to understand something very important. This will go on your record. It will be there for the rest of your life. Your record, it's not pretty. It's not a good one. Every time you get pulled over, what do you think officers are going to do? Well, I don't know, but he who has a long record has more of a chance of being, you know what I mean? Right. That's why if I were you, now this is going to end up as a conviction. I would never, even if you have a sip of alcohol, don't get into a car because it's a recipe for disaster. Do you understand? What we're doing today, from now on, it's a minimum of 30 days in jail. You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine the accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Is this what you want to do?
Yes, sir.
How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty, sentence you to this agreement, sentence you to 15 days in jail. I'll give you credit for the 1 day that you've done. I have to suspend your license. I'm going to do it for the minimum, which is 90 days. Do not drive until you get a license. So he wants to turn himself in this Friday.
Yes, Your Honor.
All right. So you need to turn yourself in this Friday by 6 p.m.
Okay.
They're going to give you the proper paperwork. You were still on bond. You are not allowed to drink. You are not allowed to use illegal drugs. You are not allowed to drive because I'm now suspending your license. So recognize that until you turn yourself in and satisfy the sentence, you are still on bond of this court. If you fail to turn yourself in, I have the 180 days to slap you with for jail time.
Yes, sir.
You understand?
Yes, sir.
All right, buddy. Good luck.
Thank you, Judge.
CC. Counsel, you ready?
Yes, sir.
Come on up. Were you able to get him to come down? Will they bring him down?
I was able to get him an escort truck.
Great.
Now he's in the tank.
Okay. Hey, guys, do you mind bringing him out? Please. It's,
Right.
262.
426.
Was the theft upstairs no PC?
It was, Your Honor.
All right. Good morning, Mr. Bradley. Sir, you're charged with unlawful restraint. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On June 8, 2026, officers responding to a domestic threat call in Harris County, Texas at a private residence. CW was dropping kids off to their mother at Kroger following an agreement. The defendant failed to show up to Kroger, so CW showed up to their residence. CW instructed the child to go to the door, but stayed in the car on the opposite side of the residence. Defendant 1 showed up and blocked his car.
Remember this? This is from last week. Do you remember this, Karina?
Yes.
Yeah. This is the one. So this is the gentleman that's in the back car that gets behind and prevents the complaining witness from leaving. He's dropping the child off and then she gets in the front, but she's on foot to prevent. And then he's trying to get.
It's the allegation, Your Honor. We've actually got.
Sure.
I think we're going to get deep into this case as we work through it.
Should I put that?
No, I know there's probable cause. We did a deep dive on this last week. So,
Yes, sir.
so Mr. Bradley, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you're ordered not to be in possession of any weapons not to go back to this location and not to have any contact with the complaining witness. If you violate these conditions, I will put you in jail. There will be no more PR bonds. I want you to understand that I'm going to do everything in my power to protect my community. If I have to put you in there at $150,000 bond, I'll just do it in a heartbeat. I will not lose sleep over it. Do you understand?
I apologize.
It's okay.
I just have a comment on the location of the.
Sure.
The location where the incident happened is their residence. So the complaining witness came to their residence to talk about the child.
It's a house or is it an apartment?
It's a house.
Whose house is it?
It is the co-defendant's.
Right. So it's not his though.
Well, I think they have a house note. They're both on the note.
Show it to me that you're on the actual note and then I'll take the restriction off. But what I'm trying to do is prevent any further things from happening. And typically the best way to do that is to separate all parties and ensure that there's no accidental bumping into. Usually that's by making sure that no one's going to go back or no one's going to accidentally see them. And that's why. If it's your house, obviously I'm not going to exclude you from your house, but I'm not going to take your word for it. I need to show me that that's the case. If you have some kind of deed or something that's your name on it, then I will acquiesce. But
one of the things about this situation, I don't know if the court went over it last week, is the child custody agreement actually is supposed to prevent them from being at that residence. So complaining witness in this matter actually violated the child custody agreement to come to this residence.
I don't have jurisdiction over him. I can't stop him from going over there. If there is some kind of agreement like that, then that's for the family courts to take over. And then, whatever they do, whether contempt, whether this or that, I don't know. But show me that he is entitled to be there, but that he owns it, right? Or he's on the lease or whatnot. And then I'm happy to do it, but just don't have contact with this person. It's very easy for them to just get on the phone. Hey, man, he's harassing me. There's so many vindictive people in this life. And the idea is to keep you guys separated. So that way, that's what we're trying to do. So just be very careful because if he goes over there again, you guys have words again. I don't want you to end up with a lengthy sentence, So let's talk about a bond. What do you think?
Bond's already set, Judge.
But he hasn't made it though.
It is not John.
So they would ask for $1,000.
But Your Honor, we're not going to object to that. I understand the facts of this case. We do.
Does he have a bonding company here?
We do. Daniel was upstairs in Felt Lake where he's coming back downstairs.
Okay, so if you're okay with 1,000?
Yes, sir.
Okay, then I'll do that. We'll set it at 1,000. Just, we need bond, if you can file the bond conditions. So no weapons, no contact with the complaining witness, no going to where he lives or works. Okay. And then we'll have you just sign a receipt. Well, no. Yeah, you're going to go, we'll release you to the bonding company when they get here.
Yes, sir.
But we need conditions signed first. And after he signs the conditions, at that point, when the bonding company is here, and we'll release them to you guys.
Text Daniel's information.
Yeah, okay.
Do you have it? May I step away from the?
Yes, sir, please.
Okay.
Bogno, come on up. All right, Mr. Bogno, do you have a lawyer today? Tell me what you're doing about that.
I had some quarrel
Why is that?
out of work.
Why is that?
I've been looking for a job
When is the last time you've had a job?
a month ago.
Okay, doing what?
Mail.
Mail. What does that mean?
Okay.
Are you high right now? Are you so high that you can't even have a sentence? What, I mean, really, what's going on? You smell like weed. Tell me what you've done to look for a lawyer, Mr. Bogano. Tell me what you've done to look for a job.
I've been doing but looking for a lawyer. I've been.
Whoa. You're here for driving on a suspended license and for unlawful carrying of a weapon. Your bond conditions are that you are not allowed to drive. Stop. You have the right to remain silent. Don't say anything at this time. You have signed an affidavit promising us that you're not going to drive. I hope and pray above everything holy in this life that you are not driving. You do not have a license to drive. Do you understand? Do not drive. You swore an oath not to drive. What were you doing prior? What were you doing before? You said male. What were you doing and what kind of income did you have? Okay. So it's now roughly a month and a half. How do you support yourself now?
Whatever I can do. Moving furniture, whatever I can do to bring it.
If you want to apply for a court-appointed lawyer, we will give you an application. But you don't get to sit at home and play Xbox all day while the entire county has to pay for you. You will be expected to work, and I'm going to bring you back in 2 weeks to see what you have done to get a job. I am also ordering you as a condition of your bond not to consume alcohol or illegal drugs, and you will be tested randomly and soon. If I find out you're using illegal drugs, including marijuana, then likewise, it will not go well for you. Do you understand? If you have 2 cases, if I have to revoke your bond and set up at 10 to 20,000, if you don't have anyone to pony up that kind of money, you will be stuck like Chuck for quite a while. Do you understand? There are choices. You either make a good choice or you make a bad choice. Do you mind giving me an application, please? I need you to fill it out. I'm bringing you back in 2 weeks and I want to see 20 to 30 applications for work. Do you understand?
Yes, sir.
So, Veronica, no weapons, no driving, test in 40 days from today, no alcohol, no illegal drugs, and then back in 2 weeks. All right.
Right, one more. Page 15, Escobar.
Mr. Escobar, do you have a lawyer today? Tell me what you're doing about that. What do you do with yourself these days, Mr. Escobar? And what do you do for a living? Okay. And what kind of money do you make a month?
I get paid $100 I get paid $100 days and I work 5 days.
Who do you live with? Who do you live with? Do you support anybody?
Just my
Did you make any attempt to look for a lawyer?
Yes, I know that.
What would you like to do now?
I would actually represent the lab.
You want to apply for a court-appointed lawyer? Okay. You mind giving him an application? You will be expected to work. You must be working full-time. You understand? Okay. All right.
Because this is what it says, once the.
Hey, Karina, did you see this?
What's the last one, Judge?
I have to give you cause number.
Yes.
244-3446.
Just online.
They did meet at the hotel lobby. They went up to the room. There was the agreement made. And,
Does it say that it was her? Because you never said, I mean, all what you're saying now was never.
yes, Judge, there was an introduction when she arrived. Detective, went upstairs to the room with the defendant in the elevator.
And it says that it's her.
Yes.
Yes, so for the damage, it looks like, they contacted her in the website. The original defendant that was contacted was the defendant that arrived at this location. Then after that, from there, met with the defendant at the hotel lobby where they exchanged introductions. And that's when they went up to the room, Judge.
And then what in the room?
And once they got into the room, The defendant offered and agreed to let them have sexual intercourse with her, and she was going to perform deviant sexual intercourse in the form of oral sex to the officer for $350.
Got it. Okay, that's what it
Yes.
is. Right. All right, ma'am, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You're ordered not to participate in these types of activity again. If you do, I will revoke your bond and put you in jail. No more PR bonds for you. You have a, no, don't. Just, you have the right to remain silent. Exercise that right. There's nothing that you can say at this point that's going to change anything. Stop. Don't. There's nothing that you can say at this time that's going to change anything. This is a probable cause hearing. Now's not the time to fight your case. You don't have a lawyer, and whatever you say, they're going to sit there and try to use it against you to prove guilt. It's just, now's not the time. If you want a lawyer, I'm happy to provide you a lawyer today. You know, no cost to you, a court-appointed lawyer. But I'm telling you that if you continue, I will put you in jail, and there will be no more PR bonds. You have already missed court once. I'm going to reinstate your bond now, but if you miss court again, I'm not going to continue to play this game. I have enough drama in my life, and I just don't need any more. Do you understand?
Yes.
Okay. So do you mind filing those conditions? No engaging in the same course of conduct as that we have here, whether online, in person, use of third parties at all. I'm going to have you sign a reset. I'm going to have you take a seat in the jury box. I'm going to find you a lawyer, and then we'll go from there. Okay? Please do not leave until you sign our bond conditions as well.
Yes, sir. You said the car was impounded and the car has a lien on it, and the bank said that they're taking the car because they have to fight with the insurance company because the car was a total loss to get paid off or whatever like that. So he doesn't have the car. But I remember your conditions, Judge. You said that if he drives a car, he has to have the document. So as long as he fills out, signs this affidavit of non-prosecution and doesn't drive, that should.
Well, we'll give him he will have a portable device.
He should, yeah.
Yeah.
That test result, yeah.
Right.
Yeah.
I need you speak Spanish?
Yes, the part that I don't speak, my phone helps me out. So he's been understanding everything I told him as far up to this point.
Tú vas a firmar un papel ahora diciendo que no vas a manejar. No me importa qué tienes que hacer en esta vida. Si tú manejas, te pongo en la cárcel inmediatamente. ¿Me entiendes? También te voy a dar un portátil que tienes que soplar cada par de horas. Si tú no soplas, también vas a ir a la cárcel y no te voy a dar fianza gratis más. ¿Me entiendes, Méndez? Tienes que soplar cada par de horas. Si tú no soplas, te vas a la cárcel. ¿Entiendes? No usas drogas ilegales, no usas alcohol, no puedes usar cualquier cosa que tiene alcohol. Okay? So, he said no alcohol, no illegal drugs, no using anything that has alcohol in it. He's swearing to us that he's not going to drive. Goes there. So, si tú no soplas, esta vez. Okay? Portable device, right? All right, good morning, Mr. Osorio. Sir, you're charged with 2 cases. You're charged with assault of a family member. You're also charged with interference with the duties of a public servant. You've worked out an agreement where they're offering you a 6-month deferred on the assault of a family member, and they're going to dismiss the second case. Is this how you understand the agreement?
Yes.
You need to understand something very important, that a assault of a family member carries an affirmative finding of family violence, meaning that should you ever pick up another one of these cases, you could be very well facing a 3rd-degree felony up to 10 years in prison. You understand? You are giving up the right to a trial, the right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you are stuck with us until you complete it successfully, if you complete it successfully, or it gets revoked. If you do something to violate this agreement, if you pick up a new case, you test positive for drugs or illegal drugs or alcohol, if you have a weapon, if you pick up a new case, if you have contact with the complaining witnesses in this case, we issue a warrant for your arrest, put you back in jail. We will have a hearing to determine if you violated this agreement. If you do, you were looking at an entire year in jail. You understand? If you complete this successfully, it does not get dismissed. This is a deferred. So if you do it successfully, you complete it successfully, there's no conviction on your record, but it doesn't get dismissed. It's a big difference between the two. Do you understand? All right. How do you plead to this offense? Guilty or not guilty? I'm not going to find you guilty. We'll withhold that for 6 months. For you to complete this successfully, you must do an effective decision-making class. No drugs, alcohol, weapons, 20 hours of community service. You must do a TRAS to see if any other conditions are warranted. What about contact with the complaining witness? Do they want contact? Do you know?
Yes, just no harassing contact, Your Honor.
What's the relationship between them?
Relationship.
My mother,
You know if they want contact? What I'd like to do is I want to make sure that they want contact first. And if they do, then we will order no threatening or harassing
They did
contact.
want contact.
They do?
Yes, Judge.
Okay.
One of them was a brother and one of them is the mother. And they said that they did want him to have contact, but they wanted him to get deferred.
Where are you going to stay when you leave, when you get out of jail?
At mom's house.
You got to understand that when you're living at mom's house, it's not your house. And if mom kicks you out because you're not complying with whatever she's asking you to do, you know, you may be very well living on the streets. And if you do, the streets will eat you alive. It sucks. Nothing good happens on the street. So even if she asks you, take out the dishwasher, clean the floors, wash the clothes, whatever it may be, anything is better than living on the street. What else are you going to do with the rest of your life? How old are you? 21, 22? How old are you, Mr. Osorio? You're 18. What's next? What are you going to do for the rest of your life?
well, once I get out, I'm going straight to work.
Doing what?
GF trash can, at the trash can company.
Did you graduate from high school? So you need to get your GED at a minimum. You will make pennies to what everybody's making $1. Just the fact that you don't have a GED or some kind of high school equivalency, you must do it. And I want you to get it while you're on this. I'll make you a deal. No community service if you can get your GED. I would rather you spend your time working to get that as opposed to menial labor, just really. If you don't, you will be looking at a year in jail, and I'm going to keep you while we get your GED. It's going to happen, whether we do it outside or whether we do it inside, because you need your high school diploma. You understand? I'll make you a deal. The minute you get your high school diploma, come back and talk. If you've done the classes, I'll take you off. The main concern is you getting your high school diploma. You understand?
Yes, sir.
Okay, man. All right, best of luck to you. I'm going to waive your fees. For as far as probation, everything there's no fee. I can't pay for the outside stuff, but just if you have any problems, come back and talk and we can work through anything. All right? Good luck. She'll explain to you more. Okay?
Because I'm working on Mr. Avalon, Joey Avalon.
Jail or bond?
He is in custody currently, Your Honor. We had a meeting today.
Oh, right. Okay, got it.
So I'm asking the court to reinstate his bond, not revoke his bond. It's a crazy long diatribe.
Tell me.
So he is putting in front of this court on a criminal mischief case. Criminal mischief case arises out of the same set of circumstances that was part of an ag assault case that was filed. He went to court for the ag assault. He has taken a 5-year deferred on the ag assault. About
4 days after he pleads guilty to the act assault, then they file the criminal mischief bond. If the court revokes his bond, he doesn't have anyone else who's going to be able to make his bond again. The offer from the state is restitution and dismiss agreement. Restitution and dismiss. He works in construction. He tells me that he can work to get the money together to pay back the restitution. Green and I have been talking today, and what we've decided, or what hypothetically we're exploring, is amending the terms of his felony probation to have that restitution be a part of the felony probation. I just went up to the 339 to try to talk to the CLO there in no hearing, so I wasn't able to talk to her. But
I don't know if they can do that, though. I mean, he's already pled to that case. You'd have to get the defense lawyer involved. You have to have the prosecutors involved. It was never even a.
Originally, I'm surprised because if it would have been filed at the same time, they probably would have considered it in the MHA or in the deferred as part of the plea negotiations. But because it wasn't filed till later, I'm assuming that's why they.
How much is the restitution?
about $1,300, Josh.
Damn, that's a lot.
Oh, for 5 years,
Yeah, I mean, right. But more so, we put a monitor on him and he just doesn't care.
Well, Judge, he was moving this weekend, and whenever he was moving, he thinks whatever the charger was, that charges his thing, it got mixed in with all the things that are moving, just wasn't able to charge it. And that's what they told me.
What do you think?
Judge, it's tough because it's not his fault that this case got filed after the deferred. I really think that if it would have been filed all together, it would have been a full resolution. It would have been included in there. I agree.
Great. We gave him a PR bond, though. I mean, you have your. Do we have to beg you to do things now? Do we really just? Is that what? I mean, we have to beg people to work to get their dismissals. Really? At what point do we say when? You know you're on felony deferred, right? You know. Can you bring it up, please? How long has he been on deferred now?
I believe since March.
Pretty much, Judge. He pled on 3/5/2026. Doesn't look like he has had any violations since then.
Let's send him for a drug and alcohol test.
Let me see what they have as his conditions, Judge.
That's most certainly a condition.
This case was filed 4/6, but let me see.
You know, with us. Do you know how serious a probation you're on now, Mr. Abel? I don't think you do. That is the type of probation that's called a 3G offense. If you get revoked, anytime you must do at least half before you're even eligible. And when you have an aggravated assault with a deadly weapon, this is not the time where, okay, 2 years, 3 years, 10, 15. Do you understand? All we asked you to do was maintain a monitor. So know that there are no issues. And you're walking around as if you have no criminal cases open at all. Your lawyer's asking for me to reinstate your bond, but I know, given the history here, if we let you out, you just can do whatever the hell you want to do. Because that's what Mr. Avila likes to do. What's the state's position on a bond reinstatement?
Your Honor, the last bond violation you saw was for him residing in a certain location. I know that as part of his condition on the felony, it was that he's not allowed to live with grandma, so I'm not sure if that was the address that he had originally listed, but had to live somewhere else based on the felony probation. At that time,
Wait, so on our case,
on the felony deferred, he was instructed not to live with grandma, just from what I can see on the notes. So I'm not sure if the address we had listed in our case originally was grandma's and he was instructed to live somewhere else. That part I'm not sure. I will have to double check with pre-trial what address he had given, because that was his first violation for residing somewhere else. And
what do you mean? Is that in the felony case or is that with us?
they're all kind of together because they're all the same complainants. The last one, do you know what the first violation is?
No, I don't. The claimants.
I thought we only have one violation. Do we have multiple violations?
I think the first one, well, the 6/8, so yes, Judge, I'm sorry, I'm looking at that, the one on 6/8/2026, that's the one violation. For residing at a different address.
I don't see the one on 6/8. I don't know which one you're referencing.
Note that I saw in our notes, so I can write case notes.
So is there a second violation?
And Judge, I'm going through my email, I see on the case note for Officer Arnita, so it could be actually push by mistake, because I'm looking through my emails and I only see this one. So it could have been an error right there. So I do say this is his first violation in regards to this GPS monitor, considering that what counsel was instructing or advising that it was because of the moving, the state would not be opposed to reinstating his bond. Since he hasn't had any violation, he's been on the road for 3 months and hasn't had any violations of that.
Where are you going to live, Mr. Avila? No, I don't want the actual address, but it's away from the complaining witnesses, correct? You're on felony probation. You should be living as if you have a halo above your head. That means no alcohol, no illegal drugs, no new cases, and to remain in compliance. As a condition of your bond here, you were ordered not to consume alcohol or illegal drugs, and I'm going to test you soon. I will reluctantly reinstate your bond. If the battery goes dead, so will your bond. And I'm not going to play this game with you again. Do you understand?
Yes, sir.
You must charge this every single day. Don't use alcohol. Don't use illegal drugs, including marijuana. Do you understand?
Thank you.
It's just no tolerance going here forth.
Yes,
And
sir.
I don't know who you have in this slide, Mr. Avila, but every time you're out there in the free world and you want to do something where you think that bond could get revoked, you need to be thinking, is there someone that's going to be ready to pony up $10,000, $20,000 for me to get out? Because if you don't have anyone that has that kind of money to bond you out, if you go to jail, you may be very well there for a long ass time. Do you understand? This is what you should be considering in the free world. It's not free at this time. You have a whole host of conditions. We will not have this conversation again. Okay?
Thank you.
Okay. Mr. Henry.
Good morning, Judge.
Good morning, bud. What's up?
Amy Jones on Docket.
Okay.
You said for bond forfeiture today, I've not heard from her. I've spoke to family members who have also tried to bring in contact with her, but I have not spoken to her directly. And I know pretrial was going to speak with you as well, because she was released out.
So on Friday, Amy Jones reported to our office and
Sure, I remember they took her in.
they did not take her in. So
What?
when
She had 2 felony warrants.
I talked to the warrants unit, I talked to a supervisor this morning because when I looked at her file, they actually dismissed her and told her to go to court. And I asked,
I just don't understand. I don't.
they said that they're looking into it right now, and I told them, well, she never reported to court on Friday, and so, right now they're looking into the situation of why she was dismissed from our office with 2 felony warrants, and so,
I just don't understand. I mean, it's like we're working against ourselves, really. I don't know what to tell you, but I can't, I'm going to revoke her bonds. She is supposed to maintain in contact with you. She's not done so. She has 2 felony warrants, really. Okay, all right. Do you want to stay on? Do you want to withdraw?
I can withdraw that.
Okay, sure. Okay, you ready?
Yes, sir.
Hi.
I'm reapproaching on Kyvon Rodgers.
Yes.
You had asked me to kind of stand down for a second while you had some time to think about it. I don't know if you had time.
Yeah, we'll do it now, but just. What is your position with regard to Mr. Rodgers? Oh, no. Just up to sign it.
Oh, sign it.
Yeah. No. You guys are good. What is your position with Mr. Rodgers as far as a bond, I guess, reinstatement.
So just while she's doing that, I will say that last bond violation when you locked him up last week, that where the allegation was that he lost his charger and he was inside and outside the house for a total of 30 minutes looking for it, looking for that charger. He did find it. Judge, I want you to know that 30 minutes.
He
cost him 4 days in
left
custody.
at 2 a.m.
Yeah.
Hey, you're not supposed to
It
leave.
was between, I think, midnight and 2. He's back and forth looking.
He had an unapproved leave at 2:22.
Yeah, looking for the charger. He says that it was beeping.
But the excuse.
So he's, and I agree that was a mistake on his part, but he's running back out in court. And over the course of the violation, about 30 minutes total. But that 30 minutes cost him 4 days in the county jail. We got a deal worked out for him where he does the effective decision-making course and then maybe this case will go away. I just need him to get out and do it, go back home, go to work and.
What do you think?
Class. I think he certainly learned his lesson.
Yeah, can you have him bring him out? Ask him please to bring him out. No
Yes,
more
sir.
calls. That's jail. I asked 2 things from you, just 2. And all you did was violate the 2 things. Your lawyer is asking me to reinstate your bond. And you know that it would probably cost all of $500 to get you out of jail, Mr. Rodgers. And there's no one to pony up even $500. Who do you have in your life at this time?
Judge, I will tell you that over the course of my representation, Mr. Rodgers, he and I, we had several long conversations about the decisions that he's made that have gotten him into this trouble and the cases he's had before and where it's all stemmed. And he knew when he left the last time from your court that if he violated his bond again, he was going to jail. And then when he violated the bond, he went to jail.
So this is the reason why I don't have much faith in him now. You know, Mr. Rodgers, why do we have jails? Why do we have jails? You know, another good reason is that when people continually pick up criminal cases, the sentences get longer, the punishment gets harsher, the bond conditions become more voluminous, because what we see is a pattern. In about 2.5 to 3 years, you are now on your 4th case. And within that 4 cases, you're now on your 3rd bond violation. Something is not. Do you understand where I'm going?
Yes.
Right, but anything you say, right, is here, but your actions are over here, and they don't jive. People tell me everything that they think we want, need to hear, but yet you go out and act as if just have no condition. La-ti-da. I'm tra-la-la-la-la. I'm going to do whatever I want to do. The conditions we place are to ensure, or at least hope, that no further cases continue to pop up, to protect the community. And so you know, he's telling me this, but I just don't have much faith that you're, at what point does someone hit rock bottom? Your actions don't say that. So I don't know what to do. See, you know, the funny thing is he's worked out a killer deal to get this case dismissed. All you'd have to do is literally 2-hour class online and the case would be dismissed. Yet you're stuck like Chuck. I don't know, man. I don't know. We've got just a couple of years. We're now on case number 4. And I don't
Judge,
know how much faith I have that he's just going to comply, you know?
right.
Just,
Well, I would just suggest, Judge, that the defense would ask that the bond be reinstated. He'd be given a 1-week reset, be back in your court next Monday. And if he hasn't done, he hasn't. If he hasn't done, if he doesn't, if he comes in with more excuses, then, you know, we'll let the court handle that.
well,
But the underlying case is just, we got it worked out. I feel like it was a really good resolution for him. And like I said, he knows going forward. He knows what the deal is going forward. He's 26 years old. He works 2 jobs. He's living there with his mom.
what job do you work, Mr.
I live downtown.
Rogers?
I live downtown in Louisville, and I have a second job at Applebee's.
So he's keeping busy. He's helping mom with the bills. You know, Judge, there is an alcohol problem. And he and I have had a long discussion about that. I know he's taken a lot of positive steps toward remediating that, and he'll continue. But this is where we are there.
When is he going to test negative for everything? When is he going to test negative?
I would hope that he would test negative today.
Be realistic. I want you to be honest. When are you going to test negative?
Will you test negative today? If you would?
No.
I don't want to say.
Well, he just tested just
On the 1st, on June 1st, if I'm not mistaken, he tested positive. So he was given bond conditions on May 15th. We're now at June 15th, so he should test negative. I would like to think 30 to 45 days for marijuana is what I understand. Have you smoked marijuana since the judge gave you bond conditions back on May 15th? No, I'm asking you, I'm just asking you a simple question. Okay. Have you consumed any alcohol since May 15th? Judge, I believe the defense would just ask that if the bond be reinstated, he'd be given a 1-week reset to get the class done. He would appear back in your court next Monday.
so. I will acquiesce, but he will have a GPS prior to release. If you step out past curfew one more time, you understand. When you're out there in the free world, you need to be thinking to yourself, if I do this, is it going to be in violation of my conditions? Whatever goes on with this case, you're going to be tested 10 days from today for alcohol and marijuana. Because by then you should have tested negative. And that's me giving you more time. But if you ever violate a condition, that will be number 4. And I'm not going to have this conversation with you again. You understand? Mr. Francis, I'm not going to do this again.
I
So
agree.
if the battery goes dead, if you go out past curfew, if you have a weapon, if you smoke marijuana, if you do anything you're not supposed to do, if you drive a car and you don't have a license and insurance, then you will be in violation of all these bond conditions yet again. Do you understand? Okay. Just, we'll have to let Veronica know and then take care of it.
Thank you, Judge.
Okay. GPS prior to release, no drugs, no alcohol, test in 10 days, no weapons. Can you test levels? Can you test levels?
We can test levels.
I'd like to know levels. So let's do another, when he gets out within 3 days, let's do another test because I want to see what levels are. Hey, can I give you guys a cause number?
Yes, sir.
260-4912. Hey, check this out. Veronica, you mind looking at this? I need to give you a cause number.
Mr. Ryan?
Yeah. 260-4912.
For your court date.
Just
Remember your court date. Man, I thought they were gonna be.
I just got an email saying that this dude picked up a DWI,
Thanks, guys. Appreciate it.
but I don't see it filed.
I'll be back.
It was a out of county,
Ah.
so we don't have to.
Was Ryan on he's on the docket today.
He's Montgomery County Judge. He was officer with 614, so he might still be in custody.
Is he in custody now?
You can pull up Montgomery County, he's in the jail. Actually, made an account last time.
Did Ryan check in? Ryan, top of page 30?
No, Judge, I got an email from
Yeah.
one company, he's in Montgomery County Jail.
Okay, so 5001. Good morning, sir.
Morning, sir.
Do you have a lawyer? Tell me what you're doing about that.
Thank you so much.
That you're not going to qualify for court-appointed lawyers. You need a lawyer to represent you. We'll give you another reset. Come on. Good morning, ma'am. What time does court start, Ms. Dixon?
8 o'clock.
You got here 12:30, right?
12 minutes.
Please, from now on, come on time. It messes everything else up. Do you understand? Really, it starts at 8, not 9:05, 10:32, 8 o'clock, maybe 8:30 at the latest. You're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, ma'am. Okay.
On May 27, 2026, officer working with Metro was advised by dispatch that defendant, a female was refusing to deboard after being instructed to do so, for not being in possession of a valid paid fare. Officer made contact with defendant and gave multiple lawful commands to deboard the Metro. Defendant fails to comply after being given several verbal opportunities and commands. Defendant stated she would not exit her train, leading officer to take hold of her arm to attempt to detain her. Officer advised defendant she was under arrest. Defendant continuing to resist by fencing her.
Wait, so they're trying to kick her off a bus?
Yes, Judge.
Why?
Because she didn't have the, paper or the. Here's the train.
Stop. Don't they give out free passes?
It's just that she didn't have the, valid card. They asked her multiple times to leave. She refused. They called the Metro Police, get her off. They asked her to leave. She wouldn't.
What was she under arrest for? What was she under arrest for, guys?
Theft of services.
Say it again?
I'll say theft of services.
Well, did they take her anywhere?
It was for Judge Holly too much alcohol and we were asking her to leave and she was refusing.
Ma'am, I'm going to find no probable cause in your case. Just be careful, all right?
Okay.
They're going to dismiss your case. You're free to go. Just be careful. And next time, if you have court, come on, time.
Okay. Hopefully.
You're the best.
Okay.
Right.
Judge, you wanna go?
Yeah, come on, bring it.
Top of 7,
Yeah.
felt pretty good first time.
2501.
Bottom of 17, Garcia, she was here earlier. Garcia. Council, you came? Oh, good, okay, we can skip that one for now. Top of 18, Ford, failed to appear first time.
2501.
Bottom of 22, third, Faith J, BDR was filed, failed to appear.
5001.
And then 23, did you above that one?
Yeah, 5003 on all of them.
Bottom of 29, Rodriguez said it was raining really hard and
Oh, God bless. Dang.
and he said.
It's 122 days old and dude's been given 3 PR bonds. No. I mean, what? The rain stops. 5001.
5,001.
One, yeah. I'm just raising it up $1.
Bottom of 31, sent an email asking for a 2-week reset.
2501.
Top of 35. Judge, that one, the one I took that was working and relation and all of that, I did not call him on Friday. So can we roll it and then I can call him today?
SFBF tomorrow, sure.
That's it, Judge. We're just waiting on Garcia to stop for her attorney.
I don't know what happened.
Garcia,
Yeah.
that was the one where you took her in.
Sure.
She came back,
She was supposed to come with Zane.
right, and you did to do bond conditions and then come to a resolution. Because it's
Where's Zane now?
they're out in how we talk.
Oh, Zane's out there now too? Oh, wonderful.
That's what I should go on.
I certainly don't know how to handle this. You know, you're on bond for a case with us and now you've picked up a felony case. I'm not down. This is not a revolving door. You know, you picked up a very serious burglary of a habitation. Do you know what conditions they placed on her upstairs, Zane?
I'm not sure.
As far as, not only that, this case is 300 days old. Do you have an offer on this case?
There should be a time certain offer, Judge.
Where's the 30 days offer?
30-day offer officially made in Florida. I received the email they said about.
So this is your first time talking to her? Am I right?
Second.
Second?
I talked to her when I was first.
Right, okay, so, but what I'm trying to get at is, like, I'm not gonna give you guys a lot of time and you guys need to figure out what you need to do in this case, but I'm setting you for later this week and you need to figure out what you want to do with this case. You must either accept the plea bargain agreement or I'm going to set your case for trial. But your case is 300 days old. You've taken off on us multiple times. You picked up a burglar habitation. It's just way too much drama. We set cases for trial at 180 days. Your case is 300. Is discovery complete?
It should be, Judge.
Okay, so let's do
We
this.
have this, we actually have this, a couple conversations, Your Honor. We'll get a trial today.
Oh, of course. You want to set up a trial?
Yes, sir.
So understand, if we set your case for trial, I will not take any more plea bargain agreements. If you want, I can give you a couple days so you can go through discovery with your lawyer here. But once we set this case, you will go to trial. I will not take any more plea bargain agreements. Not on the day of trial. You've said it. We will go to trial. If you understand. If you want, I'm happy to give you until, Wednesday or Thursday of this week to decide whether you want to accept a plea bargain agreement or whether you want to set it. But once you set it, we will go to trial. Do you understand? Okay, you guys make the decision. If you want to set it, go for it, but just no more agreements after that.
Of course.
Okay, so in the interim, I'm placing a GPS monitor on your ankle and I'm giving you a curfew of 9 p.m. to 6 a.m. I don't want you out in the middle of the night. You are not to consume alcohol or illegal drugs. You will be tested like crazy to make sure that you're not using. And let me tell you something. If you take off again, I'm going to go bananas on the bond. Do you understand? No weapons, no engaging in the same kind of behavior as in this case as well. Okay? All right. Thanks, guys. I think we're done.
Thank you, Judge.
Great. Sorry I was late today.
You're good.
Yeah, my daughter had a,
The main judge, they're
yeah. No, my daughter had orthodontist. She got like antlers. So that's messed up. That's messed up. No, she's great. They're not that bad. I'm just exaggerating. All right, guys, have a wonderful day.